Morning. I would like to get right to the heart of the matter. What matters most in this case is that the state failed to establish that either Abfubinaca or Abpanaca could be mistaken for marijuana, an argument that went unchallenged by the state. May it please the court, counsel, my name is Jacob Noble, and I want to explain why the Sands were convicted of offenses not even charged by the state. All but one of the arguments raised in the initial brief addressed why this court should reverse their convictions. However, I want to focus, for purposes of today, on the argument as to why judgment of acquittal was the most appropriate form of relief. Before I do that, I do want to discuss the elephant in the room. In preparing for this oral argument, I did review my initial brief, the answer brief, and the reply brief. And quite frankly, in all candor, this was not one of my better written briefs. For that, I apologize to the court. I saw there were some issues that were not clear, and the reason why this becomes so, why it gets so frustrating to me is because this issue, in its most simplistic form, should have established that the judgment of acquittal was the most appropriate form of relief. And here is what I mean by that. The state's information specifically charged both Anne Marie Sands and William J. Sands with knowingly distributing, selling, giving, or possessing with intent to distribute an imitation-controlled substance. That substance being synthetic marijuana and or Abfubinaca or Abpanaca. And further along, and was likely to be mistaken for a controlled substance, marijuana, due to its appearance as a green leafy material indoor packaging. At trial, the state's witnesses, and this is where the state's witnesses, not the defense witnesses, specifically testified that marijuana and synthetic marijuana look different. That was the testimony of James Stevens, who was the informant. Also, the state's expert testified as well. He too said that THC did not look like either Abfubinaca and Abpanaca. And as I did address in my initial brief, I'm going to refer to the two substances collectively as NACA, just for brevity's sake. But with that said, the green leafy material, there was nothing for the jury to weigh. There was nothing for the court to consider other than this green leafy material, which the state specifically alleged in their information, and which was not proven to be that, a green leafy material. I also want to talk about the packaging component of the state's information. The state's information specifically alleged that the packaging was what led it to be likely mistaken for marijuana. Again, the testimony of Agent Fortwangler was very clear. In fact, I asked him about this. He testified that marijuana, unlike synthetic marijuana, was packaged in clear plastic bags. Again, this is the state's own witness who testified that unlike regular marijuana, or unlike synthetic marijuana, marijuana was packaged in clear plastic bags. The reason why that was important was those were the two elements that the state alleged they would prove beyond a reasonable doubt, established that. So
you saying that for this case to be sustainable, they would have had to shown that this business sold this imitation marijuana alleged in clear plastic, and that would therefore hit one of the elements in your mind?
Yes and no to your question. Yes to the latter part, and that it would have hit, it could have possibly, it still would have been a question for the jury. But no in the sense of this is what the state alleged. I'm not saying in general.
But generally speaking, people are not, as far as the law does not allow the sale of marijuana in stores anyway, so it's sort of a tenuous comparison anyway.
Well, no, for this reason, respectfully. The state alleged that people would, the purpose behind the imitation-controlled substance is, for all intents and purposes, that someone sells somebody something that they mistaken to believe to be marijuana. In the state's charging document, they specifically alleged that one of two ways, was for it to be mistaken with marijuana was that the packaging. So in this particular case, limited to these facts of the case, the answer is yes, the state did have to prove that. And what's important is, even Agent Fortwangler testified, he didn't even know the Sands were charged with these offenses. And the other part that's important is if you look at the state's answer brief, they don't contest it. There's nowhere in the state's answer brief where they say, do they contest our position that NACA could be mistaken for marijuana? Theirs is a completely different argument. Their argument is that there were two ways to prove it, which under the statute, I agree, there is. There are two ways to prove that that a substance is an imitation-controlled substance. The first is that it can be mistaken. Again, I'm paraphrasing. And the other is through express or implied representations. But in this particular case, and this is why I get so frustrated with myself and this brief, I should have just kept it simple. In this case, under these facts, under this charging document, it was very clear that the state failed to even submit evidence sufficient for a jury to render a verdict in the case. That would go to a partial segue into issue 2. I won't go into that too much. But the bottom line being that the substances that the imitation-controlled substances were never indicated in the jury instructions. In the charging instrument, they were. And again, going back to the state's answer brief, and I'll probably be citing to that a lot because of the fact that they did flush out the issue clearly in their position, that they specifically stated that the state met their burden of proof when it showed that through express or implied representations, the imitation-controlled substance was, in fact, a control, or they represented by express or through implied representations that the imitation-controlled substance was a controlled substance. So the big question for the state is, if they did not include that argument in their brief, if that did not go unrebutted, and if the information, and another important point of this information, if you look in the record, this was the 6th amended information. And included in the information, they do have and/or. There are and/or components when they identify the substance as either synthetic marijuana and/or ab-fubinaca and/or ab-panaca. So conceivably, when they amended the information at least 6 different times, right, they could have said possibly or be mistaken, in which case you could have, even though it might not have been as artfully written as it should be, they would have been given that, the state could at least make that argument. But again, as I should have kept it simple, and I did cite briefly to this case, the McGlade v. State case, 982 Southern 2nd, 736. Really what I use that case to show is that the word and requires proof of all enumerated provisions. With that said, I'd like to reserve the remaining 3 minutes of my time for rebuttal.
Thank you, Mr. Noble.
May it please the court, my name is Richard Volantis and I represent the state of Florida. On the first issue on the judgment of acquittal, the state charged, it's our position, if you look at, I guess it's the hard record 507, the charge for possession of, with intent to distribute or sell the imitation controlled substance. There are 2 different ways to do it, and the state did at least allege both ways. Number 1, and I'd point to the fact that an imitation controlled substance known as synthetic marijuana and/or ab-fubinaca and/or ab-panaca, which is subject to abuse and which purported to act like a controlled substance as a stimulant or depressant, and that it was sold for the purpose of creating a marijuana-like high. So not only do we have the one it could be mistaken for, we also have it's basically acting like. So we did prove, or at least allege, both theories, and clearly we had the evidence at trial that this substance, I mean, they took a substance, added it to their green leafy materials, packaged it, similar, and at least similar sizes. It wasn't a clear bag, but it was a Mylar bag. And as Judge Levine pointed out, you can't be selling out in the open marijuana baggies unless you want to get caught. It was clear everyone involved in the endeavor stated that the purpose of this was to create a product to sold to head shops for people to smoke and to get high. And as a matter of fact, the implied or expressed representations, you just have to look at the labeling. The labeling has, one of which has a picture of a little guy who's a marijuana cigarette, and his name, it says Bernie on it. And there's also Puff and references to Mary Jane, MJ blends, and things along those lines. And the state would contend that those are the representations that this stuff, and we did have testimony from people who were sophisticated users of marijuana who said, yeah, there's a difference. I mean, real marijuana doesn't look substantively like this ground up green leafy material. But you come back to the fact that they get green leafy material, they put chemicals on it, and our expert testified that the chemicals, the abfunaka, or the NACA in this case, does produce a similar marijuana-like high. And that's what the state needed to prove to convict on that part. And if the court doesn't have any further questions.
Did the trial court give a jury instruction on advice of counsel?
On the,
Advice of counsel?
gave one on the advice of counsel and I believe on willful blindness as well, Your Honor. And the objection below, if was even an objection, the state had requested willful blindness and the defense said, well, that is taken up by the advice of counsel defense, which in this case I don't necessarily believe was applicable, as I stated in the answer brief, because it's a general intent crime and it doesn't apply. And then at best, it would have been harmless. I mean, I said,
Regardless, they got the instruction.
yes, on that issue, yes, Your Honor.
I want to ask you a question about this statement and closing statement the prosecutor made, and it reads, "Only in a world this shitty could you even say these were innocent people and keep a straight face." To me, that disparages defense counsel, that tells the jury that these defendants didn't deserve their constitutional right to a jury trial. I can't think of a worse statement. Can you
Well-
think of a worse statement?
Oh, yeah, I can think of, I cited several of them. One referring to defendant as the most reprehensible murderer of people on this planet, young Mr. Hitler.
But keep in mind, in the Copertino case, that's referring to the defendant and comparing him to a killer. This completely denigrates counsel. This says that because counsel is keeping a straight face and making his argument to you, that there's something wrong with that there's something wrong with them exercising their constitutional right to trial.
Well, I think, Judge Segal, you have to look at this in context, because looking at this where it came, which was in rebuttal, okay, now we're talking from the outset of the trial. Let me see, the beginning of page 504 in opening, the defense attorney said, "The state's case is a work of fiction. It reminds me of a Sesame Street episode. And if it were a Sesame Street episode, it would be brought to you by the letter I, for insufficient, incense, and inevitably innocent." So first we have the defense throwing the first bomb, saying, okay, this is a bogus prosecution, and likening it to a child's show. And then we have, when we go further along in the defendant's closing argument, you have the defendant saying, hey, look, all the state's witnesses, this is like an Oprah Winfrey show. We're going to give you a plea. We're giving you a plea. We're giving you a plea. Everybody's getting a plea except for you got to come and finger my guy. Again, extremely inappropriate. They characterized the state's evidence as not good and smoke and mirrors, and that was on page 1586 and 1615. And then finally, right before the state's rebuttal closing, they referenced Paul McCartney's Dead Mother and the Beatles song Let It Be, and basically said there's no crime here, move along, just let it be. Now, given, I don't disagree with you as to the statement never should have been made, and it can't be condoned in any way whatsoever, but you do have to look at the context of it, and when you take the context, like we're looking at some of the other cases, reference to Ted Bundy, I mean, being someone who went to Florida State, I can't think of anyone more reprehensible, but that was something where the guy was referenced during closing arguments.
What about the disparagement of people from other countries, from Croatia, Nepal, disparaging defendants, and at the same time disparaging the nationality?
First of all, I don't really think that happened and it wasn't objected to, but I would point, Your Honor, to the opening statement on page 506 where it was the defense who said Mr. Gulan is not from here, and they also said Sewall has a thick accent and an attitude. So this is something that was brought out at the outset during opening, and this wasn't something where the counsel was actually disparaging anyone whatsoever regarding their nationality. As a matter of fact, as I pointed out in the brief, the first person he mentioned, I think, was Mr. Stevens, and no attack or anything on his ethnicity or nationality. The same with Ms. Fields. And repeatedly throughout the cross-examination of Sewall and Mr. Gulan, they defense brought up repeatedly that these people are illiterate and didn't understand English. I don't know how particularly relevant that was, but those were attacks on them. And in the context of the closing argument, that the prosecutor was simply trying to explain that these people weren't the ringleaders of the operation. They were involved and they knew what was going on, but they're not the ones in charge of bringing this thing to fruition. And if the court doesn't have any further questions, the state would request you affirm. Thank you.
Mr. Voluntis, rebuttal.
First, brief correction, I respectfully disagree with counsel to this extent. I do believe the comment about the nationality was objected to. It was disparaging, either, it had something to do with disparaging the defendants or for hiring foreigners.
Disparaging defendants was your
Yeah.
objection.
Yes, and the other,
But didn't that comment actually go to the state's argument that there was a lack of understanding because of language? The statement that bothered me more was that a woman had an autistic son. What did that have to do with anything?
well, honestly, nothing. That's the answer to your question. Unfortunately, in all candor to the court, that was not something I addressed in the objection. It really was tailored more towards the foreigners, because I'm more confident and comfortable in arguing to the trial court about disparaging defendants because of the foreigners. But the part that should concern the court the most was, we all agree, including, or let me not say that, the state has already conceded that that was an inappropriate remark and it was one that shouldn't have been made. In light of that concession, it should have been rebuked. The case law is very clear on that. It's not enough for the court to just sustain an objection and say sustained, and it's not even enough for the court to say disregard that remark. The jury has to understand just how improper that comment was, and those aren't my words, and I'm not asking the court to make some new holding or some new finding. I'm asking the court to reverse because the court didn't do one of the steps that it had to take upon sustaining the objection. Affirmatively rebuking the prosecutor. That's the key language here. And what also should be...
Seems like it didn't really cause any prejudice, because you got 6 acquittals, and then the defendants were convicted of the 4 least serious counts.
I would submit any felony is serious, number one. Number two, they got sentenced to 9 months. Number three, it was all for a substance that was never identified to the jury, which again goes to argument 2. It was interesting, when the jury was told what substance the defendants were charged with possessing or distributing, they were acquitted. But when they were left with this, let me not use the word, idea of a synthetic marijuana without identifying it by name, they went to the conviction. And what's most concerning about that is that comment alone, which by the way was sustained. None of the comments that I made were objected to, let alone overruled or sustained. So that's a big issue. But it could have been that one comment alone. They must be guilty of something, right? How can you look and say these people, I think the term was completely innocent? So the jury could have gone back there and said to themselves, well, I agree, they're not completely innocent, but they're not completely guilty. So let's do that. Meaning, going back to the answer to your question, is that's exactly why. They could have split the baby and said, and again, this is all speculation, but it's the answer to where the prejudice prong is presumed. And I am out of time.
Thank you, Mr. Noble. Thank you both.
Thank you very much.
Have a good day.